Good evening, everyone. I am Senator Roxanne Persaud. Welcome to our conversation this evening. This evening's conversation is in partnership with Grow Brooklyn, and it's about foreclosure prevention. So, this webinar will cover foreclosure prevention options, alternatives to foreclosure, foreclosure timelines, loss mitigation, and a number of other topics. Our presenter this evening is Charles Harris, Esquire. He's the Director of Legal Services at Grow Brooklyn, where he leads efforts to provide free legal support to low and moderate income communities. So, Charles, welcome to our conversation this evening on foreclosure prevention. I'm going to give you the opportunity to tell us who you are, what you do, before we go into the foreclosure conversation. But before I do that, I'd like to invite everyone who has joined us, if you're joining us on Facebook, to please put your questions or comments in the comments box on Facebook. If you're on Zoom with us, you can put your questions in the Q&A or comments, and we will respond to them, as many as possible within the time frame that we have. So again, Charles, welcome to our conversation this evening, and thank you for being here. I'll now turn it over to you.
Okay, I was muted. Thank you. Would this be the time to get started on the slides?
Yeah, you can just introduce yourself, tell us what you do, and then you can introduce your slides. Yes.
Got it. So thank you, everybody, for being here tonight. My name is Charles Harris. I am the Director of Legal Services at Grow Brooklyn. We are a nonprofit that, among other things, provides free legal services, including foreclosure prevention, estate planning, and other services. So with having put the first slide on, I didn't know, Senator, if you wanted me to turn it back over to you for a bit, or if I should just get started.
You can get started. If you start by telling us, about what foreclosure is, and then you can start your presentation.
Okay. And I'm going to just keep it on the slide screen. So let me find the right slide. Okay, so as I said, this is us, and I will be putting my contact information on the last slide at the end of the presentation today. You can also just Google us. Our name is in the bottom of every slide. It's Grow Brooklyn. And we are here today to talk about foreclosure prevention. That is how our organization really got its start. Aside from the free income tax preparation, which is separate from legal services, we were here to help homeowners in foreclosure, which was something that really came into being in 2008 and 2009, which was when we got started. And then over the years, we continued with that. We started, on top of that, really getting a lot of clients with an estate issue. A borrower or homeowner had passed away, and that added an additional degree of difficulty or aspect of the whole matter, where we'd have to figure out how the whole family could save the home, what would happen with it getting passed down to the generations. We would go to surrogates court, which was the New York court responsible for handling estate matters. That proceeding might be involved in the foreclosure. And then sooner or later, we started just going ahead and assisting people with their estate planning and wills. And so, and we now do that. We do free estate planning, powers of attorney, wills for New Yorkers and Brooklynites, whether or not you own a home. And so it all kind of started with foreclosure, and we are still doing foreclosure defense, foreclosure prevention, and that's what I'll be talking about today.
Hey.
I can just keep going.
You can keep going.
And then
yes.
you can interrupt. Okay. All right. Thank you.
Uh-huh.
Yeah. So today I was going to talk about these topics. What is foreclosure? What's involved in a foreclosure? What are the stages? Loss mitigation options. types of scams, ways to combat defraud, and then time for questions at the end. Okay. So what is a foreclosure in New York State? So foreclosure is a judicial process here. This means that in order for a bank to foreclose on your house, a lender or mortgage company needs to file a lawsuit in court. In some other states, for example, foreclosure is not a judicial process. That makes it a lot easier for the mortgage company to foreclose on your house if you don't pay. So in some other states, if you're not making any new payments, the lender can just go ahead and put your home up for auction and sell it. However, in New York, they have to go through court. So by going through court, that affords you a lot more defenses, gives you more notices of what is going on, and generally takes more time. And in general, you will have more options to settle your case. So sometimes we have to explain to our clients who might be familiar with this aspect of foreclosure we see in culture or in the news or in movies. It's something that can happen quite quickly. And foreclosure is a law which varies state to state. So New York, fortunately, is one of the better states to be foreclosed in if you have to be foreclosed anywhere, simply because the bank has to follow so many procedures, which of course is as it should be. So we recognize, and I think everyone here does, that a foreclosure on a person's home is not a case like any other, and no one should lose their home on a fast track or a misletter or technicality. And in many ways, the state of New York believes this as well through its policies. As you will see during this presentation, once it is determined that the case is entered into the court system, and once it's decided that it is a foreclosure on somebody's home and they want to stay in the home, an entire layer of protections and helpful advantages exist in this process to hopefully keep the home for the homeowner, if at all possible, and give them ample time to do so. So the foreclosure process is a process where a mortgage lender files a lawsuit against you. I'll use the term you, known as the borrower or the homeowner, for the balance of the home loan, the amount that is still unpaid. So even if you stop paying until the foreclosure process is finished, you have the right to remain at the home for the duration of the process. And the duration of this process, depending on many, many factors, including how involved and active the homeowner is in defending the foreclosure, can take years. So you don't need to leave the home at all until the judicial process is over. And even at the end of a long process, at the end, worst case, the home is sold at auction and the property is no longer yours, you still retain rights as a tenant and can't simply be evicted without a formal process. And so I'm jumping right to the end there, but we'll go through the entire process momentarily. And so obviously, during the judicial process, you can always seek different loss mitigation options. Again, we'll discuss that later, to try to settle your case and not let the foreclosure get to that point at all. And so I just stress the length of the process so much and so often to people I meet, because again, we see in the culture, people get foreclosed on and they're out in the street the next day. But this is New York. And so what everybody should know is that they should not make any rash decisions or actions or enter into any unfavorable or predatory agreements or relationships, because the process is designed to give you all the reasonable time you might need to cycle through and exhaust all your options to retain your home, so often in the form of Plan A, Plan B, Plan C, etc. So it's important to talk about some of the definitions about who's involved in the foreclosure process, who those people are. When the court case starts, obviously, a lot of the time you're not sure what you're supposed to do, what's supposed to happen. So the homeowner and the borrower, the defendant, is the person who's being sued. You are the defendant. If you take in a mortgage and then the mortgage wasn't paid, the lender will start a lawsuit against you. They're not always the same people. For example, there could be different people. The owner and the person who took the mortgage could be different people. And that could be you. You could be, the owner, somebody else could have taken out the mortgage. The lender will name all the potential defendants in the suit. So even if you're the owner, but you didn't sign the mortgage, or you might be helping out your family, so you signed the mortgage, but you don't reside in the house, anybody can be a potential defendant. The plaintiff is on the other side from the defendant. So they're usually the bank or mortgage company. When the foreclosure case starts, the mortgage company will always be represented by lawyers. If you go to court, those are the lawyers that you're going to meet in court. Those attorneys represent the mortgage company. There's some good attorneys, there's some not so good attorneys, but in general, they will do what the mortgage company wants them to do. A lot of our clients are surprised and shocked by how often the lawyers who appear are unprepared or unknowledgeable about what's happening in their case. So in general, these law firms, or many of them, make their money using a business model that favors volume, quantity over quality, so that they would rather handle thousands of cases poorly than hundreds of cases well. So they push forward with their thousands of cases, and many of them meet no resistance, and they're often able to get away with taking shortcuts. And in some cases, in some ways, they can be like many mortgage servicers, where they seem not to care about making mistakes or communicating or understanding what's going on or knowing who you are or having the correct details of your situation. So it can be frustrating. And as you'll see, the system in New York is designed to kind of clarify everything and hold them to account when the homeowner, as long as the homeowner is active in the case. The process server is someone who serves you legal documents to begin the case. Generally in New York, they have to serve you in person. However, until you're properly served, the lender cannot move forward with the case. They have to try to serve you where you live. They don't always have to serve you personally. For example, if someone else resides in your property on a permanent basis, like your spouse, your daughter, and they're part of the family, they can be served on your behalf. Additionally, if you try to avoid service and the lender has tried to serve you various times and was not successful, it's possible to do something that's known as nail and mail. So if they try to serve you 3 times and nobody answers, then it's proper for them to nail the complaint to the door where you live, and they also have to mail the complaint by certified mail to your address, and that will count as service. But they can only do that if they try to serve you many times and were not successful. If you are attending your court dates, the first person you are going to meet in court is going to be the referee. In New York, all foreclosure cases first go into what is known as a settlement conference period or phase. This is one of those added layers of protection I was talking about earlier, where it's something that's kind of added on top of a typical civil case in New York. So a foreclosure is a civil case, but unlike all the other civil cases, there's first a period in which it must be determined whether there is a person who, A, lives in the property, B, wants to stay in the property, and C, is actually coming to court to participate. If A, B, and C are all met, then another layer of protection, another delay, is that the entire case basically grinds to a halt really before it can even get started or go to litigation over the merits of the case. Everything stops for this settlement conference phase. And this is a phase that can last months or even years. These are mediation sessions where you try to settle your case, usually by a loan modification or reinstatement, but sometimes there are other avenues available for you to try to settle your case. The referee is the person who's in charge of these settlement conferences. You and your lawyer are on one side, and the mortgage company's attorneys on the other side, and you will try to resolve the case one way or the other. And the referee is there to make sure the process is moving along and that both parties are working towards settlement. These conferences start off in person and generally continue remotely. And so what actually happens is about once a month, both sides appear online with the referee to explain what the status of everything is. And we'll discuss settlement conferences a little more later. Only if you cannot settle a case will it go to a judge who is the next person after the referee. So if the referee thinks the case is impossible to settle, or the referee thinks there are too many issues and settlement's not an option, then the referee will release the case from settlement conferences. And at this point, it's going to go to the judge, and the litigation process that you often see in movies or shows will start. And I wrote the court attorney there because while the judge presides and signs the orders, the court attorney is often just as important. Oftentimes, court attorneys deal with all the cases and more than the judge themselves. So it's actually, you deal a lot with the court attorney in the in-person conferences, and also it's important to really make sure that they understand what's happening, especially if you're still trying to settle. Lender versus servicer. So it's important to know the difference between the lender and the mortgage servicer. So nowadays, very often when you take out a mortgage, it's almost immediately sold to somebody else. This is not how we used to think of mortgages or what used to happen historically, but is one of the wonderful financial innovations that happened in the 1970s that we are all enjoying today. And I hope you will forgive the sarcasm. And so again, going back to the movies, there's mostly these days no more Bedford Falls Savings and Loan from the movie It's a Wonderful Life, where you know your banker or even your bank, and they lend you the money, you sign the note and mortgage, and then you deal with them for the next 30 years. Though it still does happen from time to time, to some extent, but mostly it doesn't. So now you might go to a regular bank, buy a house, take out a mortgage, and then a week later, this bank is going to sell the mortgage to some investor. That's perfectly legal and happens very often, as long as it's done properly. But it's important to know that oftentimes banks don't own mortgages. Oftentimes, some investor or some trust buys them. So, on top of all this, the bank or the investor or the trust is apparently too busy to do any of the actual work of dealing with you. And so, on top of everything else, after the owners can change, often they also will hire a mortgage servicer who works for that investor to deal with you. So the mortgage servicer accepts your payments, and they're often the people that you call and you deal with. You may recognize some of the names if you have a mortgage. Some of the names are PHH, SPS, SLS, Mr. Cooper, Carrington, Celine, Senlar, Rushmore. But generally, the mortgage servicer doesn't actually own your mortgage. They're just processing the payments, doing loss mitigation work, etc. Okay, so what happens when you fall behind? Obviously, I hope that no one has to fall behind, but as we all know, especially we saw a lot of this during COVID, people lose employment, income is reduced, unforeseen issues. And so, there's still plenty of people being foreclosed on every day who didn't expect to be. Also, rates are higher, cost of living is up, inflation seems to be up, job market, I don't know, it's not always greatest. And so it's important to know what happens when you fall behind. So if you don't make payments within the month that you're supposed to, and the next month starts, the mortgage company will start contacting you to see what happened. They will talk to you, offer potential resolutions, but what they want is for you to start resuming payments. If you continue not making payments, eventually the mortgage company will start sending you various different notices. If there's no correspondence or no loss mitigation activity, eventually the lender will start the foreclosure, hire an attorney, and will start suing you. And they'll try to serve you with a heavy packet of papers. But it's also important to know that before any court proceedings can start, there are a lot of different requirements for mortgage services or lenders to comply with. There are a lot of pre-foreclosure requirements, and if they don't comply with them, they can't maintain their lawsuit. Oftentimes, these requirements are not going to come up until the case is litigated. But if you can prove that there's something the mortgage company did not comply with before starting the foreclosure case, you can potentially have your case dismissed. It's important to know those requirements because, again, if they don't comply, it's a very good defense that you might have in court. And you also might lead to a faster settlement in case you want to keep your home. In other words, even if your case doesn't get to the litigation, just simply by the bank being aware that they might have a weak case against you down the road in litigation later, that fact can help you now when you're trying to get a modification from them or something like that. So, for example, one of these requirements is the special 90-day notice that lenders have to send to homeowners before a case can start. This notice must use the exact language that the statute says. It must be sent to you by both certified and first-class mail. It must also state a bunch of other things, for example, the days that you're behind, how much you owe on the mortgage, and the date by which you can pay it and reinstate your mortgage if that's what you choose to do. And another thing, it has to list at least 5 housing counselors in your area that can help you to avoid foreclosure. If this notice is deficient in any way, then you can potentially dismiss your case. For example, if they only attached 4 housing counselors instead of 5 that serve your area, you can dismiss your case. Or if they have incorrect information, you can dismiss. Or if there are 2 borrowers, for example, a husband and a wife, but they only sent this notice to one of the borrowers, then maybe you can dismiss the case. But it's very important to pay attention to something like this. But also it's important to know that if you're getting this notice, it means the mortgage company is preparing to start a case and they're probably preparing to sue you. And so, of course, we're going to recommend that you reach out to somebody. You can reach out to us. Or if you don't remember our information, call 311, where they will connect you with one of the many organizations who can assist you. Or, of course, reach out to your elected officials, Senator Persaud, their office. So, and if you call 311, they connect you with the appropriate agency to deal with whatever issue you're having. So with a foreclosure, we are one only one of many organizations that they send people to. So there's plenty of organizations out there who are um, designed or who have as their mission and clients, people like you, if you're in foreclosure. Um, so if you are um, if you are thinking, if you suspect you might miss a payment, that's when you should reach out. And then when you miss a payment, you should definitely reach out. And then when you get the 90-day notice, you should definitely reach out because a legal case hasn't started yet. And so, that's one positive because you want to try to hold that off as much as possible. And so if you owe maybe $30,000 is how much you're behind. Because tomorrow they might hire lawyers to sue you if the 90 days have passed, and then suddenly you owe almost $40,000 to reinstate instead of 30,000 because of all the legal costs and fees. So that moment when the foreclosure begins after getting the 90 days are up is something that ideally should be avoided if you have the wherewithal. Sometimes simply picking up the phone and keeping the servicer up to date on how you're trying to get the money back or if you want to modify, that can actually slow them down from filing the lawsuit. And maybe it never happens. And it's something in general, if you are negotiating or applying for a modification with your servicer, they might be forbidden from advancing the foreclosure case at all. So that can help as well. So it's the sort of thing that the earlier you're, the better that you are active and participating. And that will be a theme for this entire presentation today. Okay. So now we've gotten to the summons and complaint. You get this notice. Maybe you've reached out to somebody, but if you still haven't settled your case, okay. The mortgage company will hire attorneys and they will file a summons and complaint. The filing of a summons and complaint is what starts the foreclosure proceedings. They will get an index number, and that index number is publicly available, notifying everybody, including possible predatory actors, which I will mention in a bit. After they serve this complaint in the court, they will have to serve it on you, and we discussed previously about process servers, how that works. Generally, if you do find yourself facing foreclosure, you'll receive a large stack of papers. A lot of it's in legal language, hard to read, and doesn't really make sense if you're just a regular person. So just know that if you do receive a large stack of papers, either by mail or by the process server, just reach out to somebody right away because there's, again, a lot of free help available. There's a lot of free legal service providers, housing counselors who will be more than happy to assist you. So our job is to help you and assess your situation. So we notice a lot of times that people, for whatever reason, don't want to reach out to somebody. They think they can handle it themselves, or they feel ashamed or guilty or something, or that's the way they handle a stressful situation, or maybe they managed to figure out in the past before and think they can do it again. That all might be true, but in our experience, it's best to basically reach out to somebody because we're free. We're here to help and assist you. And even if we can't resolve your case, we can provide you with some good advice to see what the potential best solution is for you. Okay, the answer. So if you're served with a summons and complaint, it's extremely important that you file an answer. The answer tells your side of the story. So the answer, maybe like we talked about, like with the notice, maybe the bank didn't serve this notice to you. That's a good defense. Maybe the bank mistreated you before, you had a loan modification, you made payments, but for some reason they canceled it. It's important to give your side of the story to the court because if you do not do it on time, you might not be able to bring it up in court at all. So a lot of people don't realize, but you can't just wait until the litigation. And then even if you have plenty of valid defenses, well, you may have missed your chance to use any of those defenses. It may be too late to file your answer because, of course, it's a legal case and there are deadlines. And the court is often not going to care unless you have a really good excuse as to why you didn't file it on time. So in other words, one of the reasons the packet homeowners get at the beginning of the case is so heavy is that it's full of arguments that the bank is making as to why you are at fault. And they are going to include every argument. They have even a 1% chance of following through and arguing in court because they're just preserving their ability to do so if they want. And that's kind of what an answer is. The answer is basically the mirror image of this. You have the right to know why you're being sued. And so everything is there in their complaint. And so in the answer, it's the same the other way around. So if you were suing somebody in a case, pretty quickly afterwards, you would expect an explanation or arguments from them as to why you should lose, legal defenses or counterclaims. And so the defendants, in the case of foreclosure, the homeowner, you need to tell the bank from the beginning everything that you might possibly argue in your defense. And a lot of our clients are confused or surprised why the answer needs to go into the beginning. Because again, these are obscure legal arguments. They're very technical. Because when we meet them, we're appearing in front of the referee and talking about affordability and modifications and income and household, where how much your pension plan is and how we're going to get the money from a funding program or modify the loan. And so technical legal arguments are kind of at that point the last thing on anybody's mind, because after all, that's for later, for the litigation phase. If settlement negotiations are in the settlement conference phase, if those fail, then it goes to litigation. The legal, that's for later. However, this is only mostly true. Even though everything in the settlement phase is about the practical financial issues at the beginning, the first thing to do is to actually do the answer and file it to preserve your ability to litigate in case settlement negotiations don't go the way you want. It's sort of like insurance in that respect. And so one of those layers of protection that I mentioned earlier for homeowners is this foreclosure exception that I put in bold. So often people just don't file their answer at the beginning within 20 or 30 days of when they were served. So again, if you're a homeowner in foreclosure, that's okay. You can still file your answer so long as you do so within 30 days after your first settlement conference. Of course, very importantly, that assumes you actually did attend your first settlement conference, that you get that extension. And so if you don't file an answer, the court can grant a default judgment against you. Default just means it's a lot easier for the lender to foreclose on you, and you don't want that to happen. And the answer also gives you a better chance at settlement, because if the lender sees you're serious and that you have a good answer, they might be more willing to give you a loan modification or better terms for you to settle rather than have to worry about you beating them in court. So here we are at the settlement conferences. So previously we mentioned the referee, and the referee is the one who presides over the settlement conferences. When a foreclosure case begins, as long as you or your attorney go to court, the court is going to see those ABCs I mentioned earlier. A, you live on the property. B, you want to keep the property. And C, you're coming to court. So congratulations, you are entitled to this layer of protection and added time and enhanced supervision designed to hold the bank to account in the process. So the first thing that's going to happen is you go to the settlement conference. This settlement conference is a meeting scheduled by the court for the borrower, that's you, the homeowner, and the lender, just to discuss the case to see if it can be resolved amicably before any litigation begins. During this time, we can try to settle, usually by applying for a loan modification or other settlement options to discuss later, but there are often times that other settlement options available can be used as well. If you get a loan modification, or if you settle, if you resolve your case one way or another, that's it. You don't have to go to the judge. The case will be just discontinued, and you can walk your separate ways. It's, again, very important that you attend, because if you miss it, you might not get another chance to go in front of the referee. So it's up to the judge if they'll consider it. Why attend the settlement conference? First, it gives you that second chance to file the answer, as we discussed. The first settlement conference is also a great place to meet legal services attorneys. Free legal service providers are generally present for people who are there without an attorney. Actually, if you end up in foreclosure in Brooklyn and have to start going to settlement conferences, there is a 50% chance that the free attorney present to assist unrepresented homeowners the day you go will be me. Maybe we can take on the case, or we can assist with the answer, or we can assist you with something else related to the case, or at a minimum provide advice or referral. Another important reason to attend settlement conferences is, well, I guess why should a mortgage company give you a modification? Maybe the mortgage company doesn't want to work with you. Maybe they just want to sell your house and do nothing, or maybe they're not paying attention. Well, they're not allowed to do that by law. They have to try to negotiate with you in good faith. And if the referee says they're not negotiating with you in good faith, they can get into trouble. So once they go into these settlement conferences, the mortgage company cannot just say, nope, we don't want to work with them. We don't want to give them any modification. They're not allowed to do that. However, if you do not attend the settlement conferences, you can still bring this up to the judge after, but the judge might not accept it. Sometimes the reason the homeowner has unfortunately gotten to this stage is that the bank or the attorneys have been non-communicative or non-responsive before the settlement conferences. They haven't been answering the calls, they've been losing documents, they've been giving them the runaround. So that's behavior that may be in certain violation of certain laws or regulations, but even so, it might be difficult to hold them to account. Here in the settlement conferences, the referee is not going to put up with that sort of behavior. And at the bottom there, one of the most frustrating parts of being in foreclosure is that the amount to reinstate the arrears can be a moving target. So you can owe $30,000, and by the time you save that much, you owe 35. Legal fees, again, at the beginning of the case, they can be $5, $6, $7, $8,000 just to start the foreclosure at all. And so you can add that on top. And sure enough, through the life of the case, the legal fees will be added for the bank's attorney every step of the way, every time they come to court, every time they file a motion, more legal fees. So the exception to all of this is that as long as your case is in settlement conferences, and this could be for many months or even more, it could be for a year. I've had a case go more than 2 years. So at that time, during that entire time, no further legal fees can be added for as long as your case is in these conferences. So unfortunately, that initial amount is added to the total, but at least they can't add any more for as long as you're trying to settle the conferences. So these are all the benefits of the settlement conferences. So jumping ahead, if you settle your case at conferences, then great, you generally don't have to do anything else. However, if you're not able to settle during that settlement conference phase, then the referee will at some point make a determination, hey, we've tried every reasonable step. The bank has been doing what it was supposed to do. The homeowner tried A, they also tried B or maybe C, and nothing was working. Good luck, but we can't keep it here any longer. So it's released and the litigation process can start. So this is where your answer will matter and your defenses will matter. Cases can be litigated for years and years. If you have good defenses, the case might go to trial, you might even win. But if you don't really have any defense, eventually, depending on if you file the answer or not, the lender will get either a default judgment or a summary judgment. If they proceed with the case, eventually the home will be put up for auction, which is the finish line as far as the bank is concerned, because that's when they get their money back by finally selling the home. So I'm not going to spend a lot of time on litigation, but really this little slide represents often maybe the majority of the case. Could be years of litigating, and often people end up settling, not during the settlement conferences, but here during this period. So just because you didn't settle in the settlement conferences, that's not the end of the world, because when that process failed, you didn't lose a single option that you had in the settlement conference. So you can still modify, you can still reinstate, et cetera. So maybe, oftentimes someone in the household was out of work for the first year of the case and is now a year later making a lot of money. Maybe at that time, modification will be possible when it wasn't before. So we love to work in the settlement conference phase because that's the most favorable environment to settle. Again, very important. You've got the referee there scrutinizing the bank's actions. You've got no more legal fees. And of course, you've just got that extra time, which by itself is always helpful. The other quick thing I want to say before I proceed is there's a myth called the free house that I wanted to just dispel. So we meet a lot of people who believe that if the bank didn't do something right in how they acted with the mortgage, maybe when it was signed or how it was serviced or how they're prosecuting the foreclosure, that just because they might win the foreclosure case or it's dismissed, that now the borrower doesn't owe the bank anything and they own the house free and clear of the mortgage because the bank made minor or even major errors. So I just want to say that this is almost never true. Oftentimes the case is dismissed because the bank didn't follow proper procedure in foreclosing, as we said before, for example, with the 90-day notice. And though they can lose time and money in the process, eventually they will just start a second or even a third time until they succeed or the issue is settled. So they just keep on coming. And even if you win in Supreme Court, and I should have said earlier, I'm using the word Supreme Court because that's the court we're talking about. This is the name of the court in New York where foreclosures happen and lots of other civil cases. It's called Supreme Court, even though it's the lowest court of the three levels of appeals. So that's the Supreme Court. So if you win your the lowest court. So if you win your case in the Supreme Court, the bank can appeal it up to a second court. And if they lose, they might still be able to appeal it again to the highest court. So the free house is something that it happens, but it's kind of like winning the lottery. It's a thing that happens, but generally not to you. Okay. Judgment of foreclosure and sales. So the auction is the final stage of the foreclosure case when your house will be sold at a public auction and that money is used to pay the lender. So as I said, this is kind of the finish line from the bank and from their point of view. If they can get the case out of settlement conferences and into litigation, they have to win the case in the merits. That was when I said the default or summary judgment or a trial. And once they do that, they're still not done. Now that they've won, they will have to get permission from the court to have the auction, to sell the property to get their money back. And that means they need to appoint a referee to compute the number of exactly how much money they're entitled to at an auction, because they're not entitled to more than what they should be getting. So there may actually be some money left over at an auction, which is known as the surplus, which the homeowners may be entitled to it, unless there are other mortgages or lines of credit or other creditors who can ask for that money first. And there often isn't a surplus, though, because homes sold at auction tend to sell for substantially under their market value. So this is one reason that selling the home is often a last resort for homeowners, that they save if other options fail first, but before letting the process get all the way to the auction. So after the bank wins the case in the merits, they still have to get that referee computation. They get that, they take it to the judge and move for the judgment of foreclosure and sale. So kind of a second judgment, giving them the right to sell the home for the exact amount. And again, this is a motion which the homeowner can oppose, which can greatly delay things yet again. But after the bank has finally cleared all of these hurdles, an auction can then be scheduled. So when the auction date is coming up, this is the time when a lot of homeowners try to file for bankruptcy, which stays all debt collection actions, including the foreclosure auction. So that's something that can pause things for a little while. You can also file what's known as an order to show cause to try to stop the sale on another basis. But these are solutions that need to come within the context of a longer plan, because they're not final. They just buy time. Okay, so loss mitigation options in foreclosure. So again, these are available during settlement conferences or after or before at any time. So loss mitigation means avoiding the worst case scenario of losing your home to auction. Though often it's something either slightly less bad, like cash for keys down there, or much better, like reinstating the arrears. As I said, most often in state court, what you do is apply for a modification. A loan modification allows you to submit all of your financial documents and information to your lender, and then if you qualify, they will change the terms of your loan. It's almost like getting an entirely new mortgage. So they could change the interest rate, they could change the maturity date of your loan. Monthly payments will be different, but basically you'll have a new loan and new payments you're making. Unfortunately, right now, some of our clients are offering modifications at the same interest rate as the original loan. So maybe our client is 3.5% in their original loan, and the modification is also 3.5. But then I have another client who has 3.5, and they're being offered prevailing rates. He was offered a 7% modification. So it's not a great environment for modifications these days, or refinances. So the problem with modifications are, first, that the bank is often not obligated to offer them. Though there are FHA mortgages that they might be obligated. With a modification, the bank doesn't have to offer it. And even if you get an offer, it may be on much worse terms or even unaffordable. Grants or assistance programs. These are often different funds available or grants to homeowners. So during and after COVID, we had the Homeowner Assistance Fund, that's HAF. That's not there right now. There was another program which just expired. However, there still is a longstanding program called the HRA one-shot deal. So if you're trying to reinstate, you may be able to get financial assistance from the city toward reinstating your loan. They might be able to cover the entire reinstatement amount, or if the reinstatement amount is is higher, you may have to chip in if you can, and they will only offer it if it can be reinstated. And you have to show you can afford to make the payments, or they won't help you reinstate the mortgage. Um, the HRA one-shot deal is more famously known for rent arrears, but it's also available for foreclosure arrears. I meet a lot of people that apparently didn't know that and thought the one-shot deal was only for renters, and that's okay. I don't blame them. However, I also hear that there are people at HRA who think the one-shot deals is only for renters, which is not okay. And like a lot of things with this process, we have to explain to our clients that we just have to keep pushing past groundless denials of HRA applications. Um, so it's important to know that unlike many of these other loss mitigation options, if you reinstate your loan, if you catch up on your payments and fees, the bank really has no say in the matter. And that's a nice thing about reinstatement. Another thing you can do that the bank has no say in is that you can always sell the home yourself. So this is something that sometimes people are ready to do right away, but otherwise it's often a last resort. Common situation is, hey, I'll try to reinstate, and if I can't do that, I'll modify, and if I can't, maybe I'll try to reverse mortgage if I'm old enough, and if I can't do any of those things, fine, I'll sell. Um, if you know that you can't afford to make payments, it's better to sell earlier because every month you're not making mortgage payments, interest accumulates on your loan, and you don't want too much interest to accumulate because you keep losing equity in your home. Equity is something I haven't mentioned, but very quickly, it is the difference between, well, it's the value of your home. So let's say your home's worth 800,000 minus how much you owe. Let's say you owe a total of 500,000. So in that case, 800 minus 500 means you have 300,000 in equity. So it's an imaginary number because you have to actually find a buyer who'll pay you the 800,000, but it's helpful to keep in your head. So it's best to sell early so that you can walk away with the most amount of money possible. Of course, we do have clients who might own a house worth 500 and they might owe 800. So in that case, the home has no equity; it's underwater. That means unless you make a lot of payments over the years in the future on the mortgage to reduce it, what you owe, you don't actually save money by selling the property because zero equity is zero equity. So some clients just prefer to live on the property for years as long as they can until it's ultimately sold at auction and they're finally evicted through a formal process. And so while we're talking about equity, it's of course great to have as much as possible. However, if you don't and the house is underwater, the silver lining is the bank is then more willing to offer you a modification because they're less excited to take the home to auction and get less money than what they're owed. So they'd rather have a modification. Well, sometimes they'd rather have a modification and payments coming in than to sell at a loss. The next one is deed in lieu or cash for keys. This means the bank will just give you some money and in return you'll agree to the foreclosure process. So a lot depends on how much money they'll give you, which depends on how good your defenses are, how difficult it is to foreclose on you. So, the better your defenses, the more money they will give you. It's considered relocation money. But if your house is underwater, this can be a good option to get some cash to help you find a new place to live. And banks are often willing to give you a relatively small sum of money to save the time and effort and uncertainty of the foreclosure process. You can also try to do a short sale, but just beware there are a lot of scammers who try to convince you to do the short sale. A lot of the times they're either trying to scam you or do something improper. So it's very important to be on the lookout. Watch out for people who guarantee things and work with the proper person who knows what they're doing. Get a second opinion. Come to us. Call 311 to talk to a housing counselor, an attorney. Go to Senator Persaud's office to be connected with the proper person. So short sales, they are less common in New York. Short sales shouldn't even be in your mind unless you're underwater. A lot of people come to us thinking they need a short sale when they have equity in the property because they've been given bad advice. And one reason to do a short sale is people are scared of a deficiency judgment again. Let's say that you owe 800,000 on the 500,000 house. The bank auctions off the house to get their money back. You still owe them 300,000 because they couldn't get all their money, and then they will try to come after you for the difference. So that's something that to be aware of, but oftentimes banks don't actually try it because of it not being worth their while. Again, the process is time consuming and costly and uncertain. And most of the time, the person who lost their home doesn't have the money anyway. Now, I noticed it's 6:45. I have a set of slides on scams, but I can pause here and we can just talk in general or proceed.
Well, thank you for that. But because I have some questions that people were asking. If I could start off first with the HRA one-shot deal that you spoke about. If the HRA one-shot deal helps somebody reinstate their mortgage, does HRA place a lien on the person's home for the one-shot deal? Because technically a one-shot deal is a loan.
Yeah, that's a great question. And so the answer is yes. Um, the It does place a lien on your home. Generally, it's thought to be an improvement on the current situation. You go from owing money to the bank. Let's say you owe $50,000 to the bank. That's how much you're behind in your mortgage. You owe them $50,000. You're suffering interest on that money. It's doing bad things to your credit score. And that 50,000 goes from you're owing it to Chase Bank. Now you're owed it to the city at 0% interest. Money that you will not have to pay. There's no I got to be careful. There's often no deadline to pay, although there are. Well, there's certain
Yeah,
sometimes
the
they get a
federal government requires that the state recoups the money, try to recoup the money.
right. So there are, to the extent there are obligations to repay, the this the state isn't necessarily very zealous in pursuing those, and oftentimes those payments are forgiven or they might expire on what you owe. So there were a number of people who had done one-shot deals, before COVID, and I think a few years after COVID, those were all being taken off. So, but yeah, it's a great question. It's generally an improvement, and oftentimes sometimes people don't repay it, and there's um, you're not going to lose your home because you owe money to HRA.
Right, you're not going to lose your home, but it stays on your record that you owe that money. Because again, the federal government requires that you try to recoup that money.
That's right.
It's because I have the legislation that's trying to not have that happen. So thanks for that. Another question here. Governor Hochul signed the Foreclosure Abuse Prevention Act in 2023, and the act states that a lender cannot file litigation against you if your case was dismissed. So why are lenders still able to foreclose against homeowners?
So the main impact that we see from FAPA, or the Foreclosure Abuse Prevention Act,
Mhm.
is it was dealing with uh, not to get into the details too much, there was a decision made by a judge about for many years an uncertain part of the law that was not very homeowner friendly. And so that was rectified through this legislation to make it so that if your case was like banks couldn't, basically what it did was it fixed a gap in statute of limitations issues. And so that statute of limitations is something that it's another one of those issues that you have to really understand it and make sure you're using the right start dates and end dates and tolling and things like that, because it does matter. It can reduce the amount you owe. It can even make it hard or impossible for them to bring a new action. But you have to make sure that you're calculating it right. But anyway, one of the biggest impacts of FAPA that we've seen is what it does is it prevents the banks from basically not having to worry about the statute of limitations in many cases.
Right. Thanks for that. Another question is there a maximum number of settlement conferences?
Yeah, that's a great question because it gets to the I'm sorry, turn my screen on. It gets to the idea of it gets to the idea of the settlement, the concept or the spirit behind it, really. And so it really it's about exhausting. On the one side, the homeowner is going through, cycling through and exhausting all of their options to keep the home, because the name of the game is we're trying to keep the homeowner in their home. And so that's the one variable on the homeowner side is, how long, and this can take a long time. Like there can be delays that are reasonable or explainable, and then things can extend a long time. And so you're giving the homeowner that chance. That can delay the process a long time. Again, Nowadays, we meet about once a month to check it, to explain to the referee what's going on. So, on the other hand, sometimes banks are very uncooperative or they're slow, sometimes inexplicably. They just can't get their act together. They're not doing what they've been asked to do. And so, for those two reasons, settlement conferences, there is, I had a case that was there for over 2 years. Um, yeah, it was close to 3 years. I mean, it happens, but it's not, so there's no expiration date. It's basically just you're going through all of your options to see if you can settle. And at some point, the referee says, okay, there's nothing left to do. We haven't tried before. The banks eventually, at the end of the day, they did what they had to do. It seems like maybe in the future you have a plan, but we can't keep it here anymore. Good luck. We know this takes time. I might even stay your case a couple months to give you that extra time, but I just have too many cases to keep in settlement conferences.
Okay. So this is this person asked in multiple parts to this question. First, if my case is dismissed, and I know you spoke about that, there is no such thing as a free home. So if the case is dismissed, you cannot say that you no longer owe the bank. Right?
Well, yeah, that and I should be answering this. I should be including this in my answers more. Um, anybody with, I mean, if you're just interested in asking theoretical questions, I'll try to answer them, and I'll try to answer all your questions. But
Yeah, we're gonna.
if you really want to know anything about your personal situation, please look at the information on the screen and give us a call. Um, but um, but if your case has been dismissed, it depends on what happened to know whether under what circumstances or how or whether they can sue again. They're the free home is it's when I'm talking about it with somebody, it's basically to give them the bad news that actually, great, you've bought yourself time, or you've gotten something favorable happen to you. Maybe you owe less, but the mortgage is still there.
Yeah. Okay, these are just general questions, and we were going to remind everyone too, if they want, if they're personal questions specific to them, they must contact Grow Brooklyn based on your information is there. And someone wants to know, how do you know that a housing counselor is legit? Too often you hear people say, oh, a friend of mine told me about going to this person, and I went, and something happens that's not favorable to the person who went. So how do you know that? What do you have to check for to verify that the counselor is a legitimate person or the
So,
entity?
yeah, so there's a couple of ways to answer. So I'll give all of them, although I have some of my favorites. But and then there's a housing counselor for a lot of different. Maybe you need to repair your home, maybe you want to get a certain kind of mortgage, different things. But in the context of foreclosure, um, housing counselors should not be charging you money for what they're doing for you. For example, so you may go to an attorney and they'll charge you money to defend the foreclosure, but a housing counselor, they say, hey, we'll modify your mortgage. Here's what we charge. That's something that shouldn't be happening, and there are
No?
plenty of companies that do that. I didn't. I skipped the end of the presentation, um, and but just before I forget, it is about all the different scams there are, but one of the major scams is the foreclosure prevention scam, because you know people in foreclosure are desperate. They feel a sense of urgency, and so they're going to make choices or listen to people they would normally, if they had all their time and you know calmness, might be more skeptical to talk to. And so a lot of people in foreclosure rescue scams, they may say, hey, sign these papers,
Mhm.
sign me the deed, and then I can get you out of it. Or I know they often, again, they use they guarantee you things that they have no ability to guarantee you. Um, Anybody you're working with, try the phone number that they give you. You can even go to their office, see if it's real. Um, you know, there's plenty of housing counselors that it's best if you found them, not they found you. Again, 311, fortunately,
Yep.
they're a central clearinghouse. You call them, you say you want estate planning, Grow Brooklyn. You say you want this, somebody else. They say, well, foreclosure prevention, maybe Grow Brooklyn, maybe somebody else. Other organizations do estate planning too, but you need housing counseling, foreclosure prevention counseling, repairs. They send you where you're supposed to go, and those are all legitimate organizations.
Thank you. Again, I want to remind everyone, if you need assistance, you have questions that you wish to have answered, please contact Charles Harris, staff attorney at Grow Brooklyn. The information is on the screen and it will remain on our page. You can, or just Google Grow Brooklyn and find their contact information, and you can contact them, schedule an appointment, ask the questions, because remember, this is about ensuring that you remain in your house. We do not want anyone to lose their home because they are unable to afford the current mortgage, or they missed a couple of payments, etc. And so my final question to you, Charles, and then you could quickly run over a couple of the scams that people should look out for. Uh, this person wants to know, what if the mortgage company refuses payments and causes them to fall behind for whatever reason? And this again is a question that, uh, to be specific, if it's specific to them, they can contact you. But in general, what if the mortgage company refuses to take a payment and causes you to fall behind? What are the options for you?
Yeah, I mean that's a common that's a very common reason for that might be the most common reason for foreclosure to happen in when it's not you just losing income, um, is that or having to make it not being able to afford the mortgage is that sort of servicer issue. And so there are regulations and procedures that they're obligated to follow. You can, aside from getting help, you can, or the person helping you might uh, uh, file or force them to comply with certain procedures through a qualified written request or notice, uh, QWR. I'm forgetting the other term for it right now. So the so there are, you can just call, you can write them an email, but there are certain forms uh, of written letters you can send them that they actually are legally bound to reply to in a certain way and answer in a certain way in a certain amount of days to explain why they're acting, to provide information. We've sent those, and so that's servicers can be, unfortunately, it's frustrating. They can be very difficult to deal with. You don't really have control over who your servicer is. We do have clients that say, I can't, like, they want to change, they want to refinance their loan just to change their servicer because, and servicers do change pretty frequently. So it's one of those things that it's unfortunate. Yeah.
Okay. So if you could just quickly, as our time is running out, just to go over, we know deed theft it's on the rise, and we've seen what is happening in Brooklyn, particularly in certain parts of Brooklyn, and we see the Attorney General and the state, all the things that we're doing to prevent deed theft. Can you go? Oh, did we lose him?
I'm still here.
Oh,
I
okay.
had to go over my slide. So
Okay.
yeah, and I'll just try to, maybe spend more time on some or less than the other, maybe just for a
Mhm.
minute.
Okay.
Where were we? So this is foreclosure, and then we're getting over deed
Scams and
fraud or
mhm.
yeah. And I know we're out of time. So let me just make sure that I touch everything and I get to, I talked about these foreclosure rescue scams. I definitely wanted to touch on those because um, they're very insidious. They're people need help, and so these people at a dark time, and so these people come out, and
Carry on.
another thing I didn't say about maybe not about who you choose, but also just ask. This is a case oftentimes you're working with them, and they're just saying, "Oh, hey, I applied for the modification," or "Hey, your modification was denied." "Oh, hey, I sent this in," and you should be asking, "Can you show me? Can I have a paper trail of what you sent?" Um, so lease back equity stripping scheme. The scammer says, sign over your deed so I can refinance for you. This is similar. Again, your credit's bad, but mine is good. Let me refinance the loan for you. Watch out for those. Home repair scams. They can include blank pages, or they can sometimes it's even happen where you sign your deed while you think you're just fixing your roof or something like that. Hard money lenders are not exactly a scam necessarily, but it often ends in the same place in that it's rare that you're in enough trouble that you're in foreclosure and you're trading your original loan to a loan which is you know the terms are much worse. And most of all, this is not a 30-year loan. These are often a 1-year loan right. The rates are right under usury. So this, again, it's something you might be in foreclosure, and this might be, you think this is you're reaching for a lifeline. Just something it's generally not the way to go. Short sales, again, it's very scam. A lot of scammers like the short sales. And oftentimes we get a lot of people that they have equity in their property. They shouldn't even be thinking about a short sale. And then finally, the partition actions, which I will talk about. I can talk about this or not, but this is, it's when more than one person on the property. And so then one of them sells it to a scammer, and then that person has the right to have the property sold so they can get their half of the property, their sixth of the property. And how it plays out in reality is often it is, if me and my friend buy a property, my friend is normally not, or my brother or my wife is normally not going to sell their interest to a scammer and put me in a bad spot. But let's say I have 6 children, I die, and then each of the 6 of them own their sixth, and I might have, a son out in California who has no idea what's going on. Somebody walks up to him and says, here's $20,000 for your sixth, for a sixth that might be worth 200,000, and then they force the property to be sold through a partition action. So these are all things to be aware of.
Well, thank you very, very much. This has been an informative conversation. I appreciate always working with Grow Brooklyn, whether it's in tax preparation or these kinds of webinars where we keep the constituents across District 19 and beyond informed. To our viewers, if you joined us on Zoom or on Facebook, we appreciate you joining us. Please contact Grow Brooklyn at the numbers that's on the screen, or just Google Grow Brooklyn and you can reach out to them to schedule an appointment if you have questions, whether it's anything to do with foreclosure, loans, whatever it is. You can reach out to Grow Brooklyn and they will be there to assist you. There are other organizations. If you wish to find another organization, please call 311 and explain to them what you're looking for, and they will give you a referral to an organization that you may want to use. But again, this is the information for Grow Brooklyn. It's an organization that we partner with frequently to share information across the community. So again, Charles, I appreciate you coming on tonight. I want to say thank you to Michelle and Dennis, who were doing everything behind the scenes and who are here late in the office here in Albany to ensure that the constituents are receiving the information that they should. So again, please reach out to Grow Brooklyn at the information that's on the screen, or just Google them, or just call 311 and they will refer you. So again, thank you everyone for joining us this evening. Thank you, Charles, and have a great rest of the week, everyone.
Thank you very much.
Thank you.